right, thank you. So good afternoon, everyone. Welcome to Mr. Balfour's Poodle, the uncertain future of the UK's House of Lords. I'm going to get straight into it and introduce our speakers. We have a lot to discuss today. My name is Jonathan Su, and I'm the Section Chair of the International Section. I'm delighted to introduce our panelists, starting off with Lord Charles Courtenay, who is the Earl of Devon. He owns and operates the Powderham estate near Exeter, England, focusing on sustainable heritage and land management. In 2018, he was elected to the House of Lords as a crossbench hereditary peer, where he champions the interests of Devon and speaks on technology, heritage, agriculture, and the environment. Lord Courtenay is also a barrister and a partner of Moore's. His practice focuses on intellectual property and other complex commercial disputes, with a particular emphasis on cross-border technology and finance matters. He is well-versed in international patents and copyright litigation involving the US and UK in particular. As a dual qualified advocate, he has hands-on experience in courts and arbitrations across both jurisdictions. Previously, he led the European IP dispute team at Latham Watkins. He also spent 8 years living in LA before relocating to London. My Lord, welcome.
Thank you, Jonathan. Very nice to be here.
And joining Lord Courtenay this afternoon is Alexander Rufus Isaacs. Alexander is an Oxford University graduate who began his career as a barrister in England in 1982. He moved to Los Angeles and was admitted to the bar in 1988 in California. He's a litigator with an emphasis on media, entertainment, and business disputes. Many of his cases have international dimensions. He co-founded Rufus Isaacs, Ackland, and Grantham in 2010. He's the president of the Beverly Hills Bar Association for 2023 to 2024, has been selected as a super lawyer for 2017 to 2024 by Southern California Super Lawyer Magazine, Lawyer of the Year for Copyright in 2023 in LA by Best Lawyers, and has been honored as a media litigator by numerous international law and business organizations. Gentlemen, the floor is yours.
Thank you, Jonathan. That's very kind of you to give us such a nice introduction, and welcome everybody, and thank you for tuning in today to a very exciting and interesting and I think unique program in the annals of the BHBA. It is my great honor and privilege to welcome my good friend Charlie Courtenay, who is the 19th Earl of Devon. Charlie, 19th is a big number. Tell us a little bit about the Courtenays.
Well, technically, I'm the 36th then Earl of Devon, and
I do apologise.
But we're humble and we count only from 1558, which is the fifth creation of the earldom. The Courtenay family actually is a French family. The name Courtenay comes from a town just south of Paris that was fortified by Athon de Courtenay 1,000 years ago. But we moved in 1152 to England and took root in Devon. And we've been resident in Devon since that time. We married into the Norman families, the de Redvers, who had become Earls of Devon in 1142. And ultimately, we inherited that title when they ran out of male heirs in about 1235. And since then, the family's been Earls of Devon for periods of time. We've lost our heads 2 or 3 times. I mentioned there were 5 creations. That was largely due to beheadings. We fell foul during the Wars of the Roses. We were on the wrong side on numerous occasions. And we last fell foul of King Henry VIII in 1536, when we supported his original marriage to Catherine of Aragon. And I'm sure many of your members may not be that familiar with English medieval history, but you probably will recall Henry VIII and his 6 wives. We were his first cousin, and we were very supportive of his original marriage to Catherine of Aragon and the Catholic faith under which he was married. So when he abandoned that wife to marry the saucy Anne Boleyn, we were we thought that wasn't a good idea. But being his cousin, we were also his nearest male relatives. And so should Henry VIII have died without a male heir, the kingdom would have fallen to his cousin, Henry Courtenay, the Marquis of Exeter. This was obviously a challenge for Henry VIII, and he therefore took umbrage at his cousin's support of his original marriage and had him locked up in the Tower of London and ultimately beheaded. However, the family survived. I am the descendant of the cadet branch who lived at Powderham Castle, and we were able to pick the title back up after about 250 years of abeyance. And in 1832, we were declared the rightful heirs to that medieval earldom. And we have enjoyed the earldom and the opportunities and privileges and challenges that it presents ever since.
I often ask speakers to give us a little bit of background. I don't think we've ever had a background like that before. I also noted that your relatives are actually even mentioned in Gibbon's Decline and Fall of the Roman Empire, which really does take us back a long way.
Yes,
I don't know.
Gibbon has an interesting digression. He puts in a sub-chapter on the Courtenay family and tells, because the real highlights of the family sort of predate our move to England in 1150, because we were crusading knights during the First and Second Crusade. So we became sort of kings of Jerusalem and emperors of Constantinople and did some exciting things in the Holy Land. And reflecting upon our current global circumstances and obviously the tragedies that we're seeing unfold in Palestine, you think back to responsibility for these actions, and many people think to the Balfour Declaration of 1919, I think, but you could probably trace responsibility back about 1,000 years to the time that the Europeans were last kicking about in the Holy Land and messing things up. And actually having that particular family story and narrative and relationship with European history does allow a bit of perspective. And it's something we'll probably come to when we discuss the role of hereditaries within the House of Lords.
There's a lovely story when Edward Gibbon presented his life work, The Decline and Fall of the Roman Empire, 8-folio volumes. The poor man was ushered to present them to George III at court with all the finery and all the courtiers, and there he is, a fairly elderly gentleman, staggering under the weight of these 8 huge books, advances to George III, places them at George III's feet, and then backs off, continuing to face George III, of course. George III then has to say something, and all he comes up with is scribble, scribble, eh, Mr. Gibbon? So you're here in some ways to support the hereditary principle embodied in people like George III, Charlie. We were talking a little earlier before the program started about the efforts to reform the whole House of Lords, which go back a long time. But I think before we venture into that, maybe you could just explain to us how you, as despite your ancient lineage, you were a lawyer here for Latham Watkins, practicing in Los Angeles. You're a lawyer back in London. How do you end up in the House of Lords today? How is it structured, and how did you come to be part of it?
So it's the House of Lords is currently composed of a real mixture of members. No one is democratically elected into the House of Lords. It's obviously the second chamber. The members of Parliament in the House of Commons, the MPs, are elected by their constituents. The House of Lords is composed of multiple different groupings, the largest number of which are the life peers, those who are appointed to the House of Lords for the duration of their life, which has been a form of entry to the House of Lords since the 1960s. There's a group called the bishops, who are the bishops of the Church of England, of which there are, I think, 26 members, and they are only able to sit in the House of Lords for the duration of their time as a bishop. And then there are the remaining rump of hereditary peers, of which there are 92, who sit by virtue of the fact that they are hereditary heirs to ancient titles, to titles that pass by typically male primogeniture from generation to generation. And obviously, traditionally, going back to the time when my family first sat in the House of Lords in the 11th, 12th, 13th centuries, typically the entirety of the House of Lords was these hereditary peers. And it's only really since the last century that they've become a minority within the House of Lords. And in 1999, Tony Blair, on the promise of his manifesto to reform the House of Lords, abolished the right of hereditaries to sit in the House of Lords. But in doing so, there was a bit of haggling and a bit of trading to allow him to get his legislation through, which allowed 92 of those hereditaries to remain. And the purpose of this was something of a halfway house. They hadn't fully revised the House of Lords and the membership of the House of Lords, but they decided that there were at least 92 members of the House of Lords who were useful, active, and they didn't want to get rid of them. And so they introduced a temporary system whereby if any of those 92 remaining hereditaries retired or died, there would be an election to replace that hereditary amongst the members, the hereditary members of that particular political party of which the hereditary was a member. And so now there is this rather peculiar process of a hereditary by-election. And so in order to gain a seat in the House of Lords as a hereditary peer, it is a quasi-democratic process. You have to apply. I applied in 2018, following the death of my father in 2015. I inherited the Earldom of Devon. In 2018, a vacancy came up on the crossbenches and I applied for that vacancy. And it was a competitive election. There were 18 candidates for the vacancy. There were 28 electors. Those are the other crossbench hereditaries that sit in the House of Lords. And we had this rather strange sort of somewhat Game of Thrones style process where you're sat around, you have to write a 70-word manifesto. So a very brief introduction to yourself and why you want to sit in the House of Lords. You have a 4-minute elevator pitch, which you deliver as to why you'll be a useful member of the House of Lords. And then there's a series of questions that are thrown at you during this hustings, where you as the candidates sit in a ring, a circle in the room, and the electors sit in a circle outside the inner circle, in a room called the Moses Room in the heart of the House of Lords. And it is very sort of feudal in some respects. And they throw questions at you and you have to answer the questions that come. And then they retire to vote on who they think is the most appropriate candidate. And I was fortunate enough to get elected on my first attempt. And I put that entirely down to the fact that at the time I was a thrusting young litigator at the American law firm Latham Watkins, and I'm sure that's exactly what the House of Lords wanted, was access to the wisdom of the American legal system.
Can you explain what a crossbencher is and how the party structure works in the upper house? Yes.
So the upper house, the seats in the upper house are allocated not on a sort of democratic process. They're allocated effectively on as soon as you get given a life peerage, you remain in your seat. So we have a Conservative majority, the Conservative Party, the current party of government in the United Kingdom. You have a Labour opposition. You have a number of Liberal Democrat peers. And then you have quite a large group within the House who are unaffiliated and non-party political. And they are known as the crossbenchers. And literally, the House of Lords, like the House of Commons, sits in benches opposite each other with one party, the governing party on one side, the opposition party on the other. But there's some benches that run between those two sets of benches, which are called the crossbenchers, and that's where we sit. And so we are unaffiliated, entirely independent. And it's rather nice because you don't have a party political whip. You also, the total number of peers in the House of Lords is approximately, I think, 760 or approaching 800. It's the second largest legislative body in the world, behind the Chinese Parliament. And approximately, I think probably 300, 350 of those are Conservatives. You've got a a couple hundred Labour, 100 or so Lib Dem, but the cross benches have about 200 members and are effectively the casting vote in many respects. And one of the challenges of being a crossbencher is no one tells you how you should vote. So you have to actually make up your own mind, which can be quite tricky. There are plenty of issues that are quite balanced and quite challenging. But it means you really have to engage and really understand what's going on. And that's been really gratifying for me to really try and understand the legislative process and how we can hopefully do a proper job with it.
I mean, I think that's one of the things I'd like to explore a little bit further. As you know, but till 2018, you were not, so I understand it, a professional politician. You're now a legislator. You get to review all of the UK legislation. How do you acquire the skill set to be able to function as an effective legislator?
One of the real plus points of the House of Lords is very few of its members are, or not very few, but surprisingly few are actually professional politicians. You tend to have former members of Parliament elevated to the House of Lords, and they are clearly political. But many people in the House of Lords have other careers, other professions, and come at it from a very different place. And I think that allows the House of Lords to have a much more subject matter expertise. You'll find you're debating an esoteric topic of, for example, veterinary law or veterinary legislation, regulation. And you'll suddenly find, on all sides of the House, you've got 2 or 3 world expert former or current Oxford professors or Cambridge professors in veterinary medicine, and they just happen to also be members of the House of Lords. And so when they get up to speak, they're speaking with absolute wisdom, and the Lords is very keen to encourage people to maintain outside interests, outside expertise, and to bring that to the House. It can present challenges from the point of view of conflicts of interest, because you often find that you're talking on matters that are of personal relevance. For me, that's happened a lot because I contribute a lot on intellectual property matters. There are not that many IP savvy members of the Lords, and so as an intellectual property litigator myself, I do tend to contribute a lot. But so long as when you get up to speak in any debate, you declare your interests, then the House is happy to hear from you, and they will listen to your contribution, safe in the knowledge that they know why you have that expertise and how the legislation you're debating may impact your own interests. When I joined the House in 2018, 2019, we were just going through Brexit, or Brexit had been determined, but we were sort of legislating our way out of it. And one of the biggest impacts on the United Kingdom of Brexit was our leaving of the European Common Agricultural Policy. A lot of European policy impacts how you farm and the subsidies that are provided for farming across the UK. And of course, one of the benefits, if that's how you think of Brexit, of the process, was that we got control back of our farming subsidy process. And so we legislated the Agriculture Act and the Environment Act, how we regulate and manage our land. And in my other life as an owner and proprietor of Powderham estate, I am a farmer. So I was able to really get involved in that and really engage with this whole new process of environmental land management that's impacting how the UK manages its land and feeds its people. And it was really interesting for me to be able to do that as someone who has experienced the challenges of farming in the UK, and really bring that wisdom to bear in the House of Lords and make certain adjustments, amendments to the legislation that hopefully will improve it.
So is it right to say that the House of Lords' job is in many ways to review legislation, that it does not initiate it?
Yes, certain bits of legislation are initiated in the Lords, but for the most part, the legislative programme is directed by the governing party in the House of Commons, and most legislation is introduced in the House of Commons. But the process in the House of Commons is much less deliberative. It follows very much a party political approach. Amendments tend not to be effective in the House of Commons because the governing party tends to have a majority and it can smash anything through that it likes. But in the House of Lords, the governing party necessarily does not have a majority. And so legislation can be considerably, and usually is, considerably amended. It's rarely blocked by the House of Lords, but it's amended and improvements are made. We've just over the last few months been dealing with, and we're still fighting the House of Commons over the immigration legislation. The Conservative Party have come up with an immigration policy that suggests that illegal immigrants who arrive on boat on the south coast of the United Kingdom should get deported to Rwanda, which is a country in the middle of Africa, a hot country. And the idea is that that this will discourage people from seeking to illegally migrate into the United Kingdom, and has caused an awful lot of concern as to obviously issues of human rights and practicality, and you know, is this really the appropriate way to treat a very challenging migration problem? It pretty much sailed through the House of Commons despite considerable opposition from Labour and the Liberal Democrats, but it very much has been stalled in the House of Lords and has been sent back to the Commons at least on one occasion. I think it's about to come to us next week and will probably be sent back a second time with amendments that actually seek to ensure that it is compliant with international human rights law, because the concern is that it may not be. And in that way, the House of Lords allows the Commons to think again, to think again, to think again. It won't ultimately block the legislation, but it hopefully will improve it and make it better.
Would it be right to say that, you know, rather than having, you know, formal powers to block and force through things that the Commons disagrees with, that its influence is more persuasive and that it makes appeals to, you know, human rights and various other things you've mentioned, and that these are considered seriously by the House of Commons and result in better legislation, do you think?
Yes, you've got a number of people there who are both former ministers, but obviously retired from active politics. You have lots of former civil servants, and for example, folks that have worked in the Foreign Office as ambassadors. You have former military generals, etc., and a number of retired law lords, so former members of the Supreme Court, etc. So there is such a bank of wisdom within the House of Lords that it allows new idea, or you know, it allows new legislation to be challenged with an awful lot of wise heads, and it does, in certain circumstances, really cause the government to think again. We just last year, the government was very keen. This was the last days of the Boris Johnson government. Was very keen to push through something called the Retained EU Law Bill, the Rule Bill. And this was a bill that aimed effectively to remove all retained European Union law automatically by December 31st of last year. Whether or not it had been replicated in English law or existed in the English statute book, it was the sort of, for them, it was the full stop on Brexit. We'll finally get rid of all this beastly European law, in their view. And the House of Lords really sort of went to town on this piece of legislation, pointing out that there are so many pieces of really excellent and valuable and important legislation that protects the environment and the rights of employees, for example, and discrimination rights, etc., which are baked into our legislation, but all of them derive from previous European Union legislation and just haven't been replicated in our own statute book. And to automatically rub all of this out and force us to start again, you will be removing so many protections and safeguards that people have grown to rely upon. And thankfully, the government, after a number of months of posturing and toing and froing, finally saw sense and realized, okay, this may not be the most efficient way to rid ourselves of European law. We might need to go back to the drawing board and actually do it iteratively, slowly and correctly. And that's what they're now doing, which was, very much down to the House of Lords, pointing these things out, making the MPs think again, and public opinion as well, because I think what the House of Lords does is it acts as a bit of a sounding board for public opinion, which doesn't get an opportunity to be heard within the intensity of the political fray in the House of Commons. And I think certainly many Americans that I meet are aware of the English parliamentary or the British parliamentary process, but they're aware of it principally from watching Prime Minister's Question Times, which is obviously where questions are thrown at the Prime Minister of the day in the House of Commons, which is a real bear pit, and lots of jeering, lots of booing, lots of shouting, lots of cheering. And there's a real theatre and a drama and a tension and an aggression to the way in which legislation is debated and passed in the House of Commons. The Lords is very, very different. It's very much more genteel, very much more comfortable, very much more respectful, and there is a much more deliberative exchange within the House of Lords and a respect amongst its members, which allows quite challenging and hot topics to be properly and quite maturely debated. And I think that balance between the two, the intense politicization of the House of Commons and the political battles, and then the slightly more considered and reserved approach of the House of Lords does provide a healthy balance between the two.
It sounds almost as if there's an exercise here of what I would call soft power of the former ministers, former senior civil servants, diplomats, generals, people with some real world experience and respect. Culturally within the House, how do those people treat the appointments of, for example, 29-year-old, former assistants to the Prime Minister? Do they not? Obviously they're never going to be, I assume, rude. There's always going to be that politeness. But is there not a feeling within those ranks that they are somehow being belittled by the appointment of people who are not of the same sort of experience?
I don't know. There was certainly I was present when the lady that you're talking about took her seat and swore her oath of allegiance. And I think everybody feels that if you get to the House of Lords, once you're in, and you're there to be heard from. And there is a real value to that diversity of voice. There are many ways in which people get to the House of Lords. There are the political appointments that we've discussed, and obviously the hereditary and other appointments. There's also a process quite recently introduced called the House of Lords Appointment Commission, which is sort of colloquially known as the People's Peers, where sort of your non-traditional persons, good servants in their community, can get appointed to the House of Lords. You apply to it's called HOLAC, House of Lords Appointment Commission, and you can apply to that, and they'll tend to appoint people who are not from your usual background. And I think the House tends to be really, certainly I found, joining as a relatively young hereditary, people are so welcoming, and they're very keen to encourage you to find your voice and to make a contribution. Too many recent joiners, or too many people that join the House of Lords as political appointees, and I'm thinking of people who have been appointed possibly due to their financial generosity to a particular political party, and the Conservative Party has done a lot of this of late, where their Conservative Party treasurers, which tend to be people who have donated a 7-figure sum to the Conservative Party, find themselves joining the House of Lords as a life peer. And very few of them make active and noisy contributions. And that's rather unfortunate because, it is a real privilege to have an opportunity to contribute to that debate. I think it really lessens the value of the House of Lords to have people who are there simply because they bought their way in. But equally, it is entirely consistent with history. And the reason I say this is there's a very grand family that, Dan, you will know of. Some of the members of the Beverly Hills Power Station may have heard of, and called the Duke of Devonshire. And he lives at Chatsworth House, which is one of the grandest houses in England. And I had the good fortune to visit Chatsworth a few years after I inherited the Earldom of Devon. And the Duke was not in residence, but I left him a note saying, "Dear Duke of Devonshire, I'm the Earl of Devon. I'd love to meet with you someday and talk about our county," because Devon and Devonshire are obviously the same place. And he very sweetly wrote me a letter in response saying, "Dear Earl of Devon, I've never been to Devon. It's not my county. It's entirely your county. We just bought the title when you vacated it for a couple of 100 years in the 1660s." And of course, you know, that family were very wealthy. I think they made lots of money in vulgar things such as trade and mining and such like, and purchased the title when the Stuart monarchy was rather short of money. And so this purchasing of a right to sit in the House of Lords is certainly nothing new. And one of the interesting things about this wholly imperfect way of constituting the House of Lords is I don't think anyone there feels that they're there by right, or that they have some valid reason for being there. Everybody feels that they're there slightly on borrowed time, or they're slightly embarrassed by their presence there. I think the majority of members of the Lords feel like somewhat like frauds in being in the House of Lords, but that makes them all work their socks off to, you know, deliver the kind of service that they feel the nation deserves. And you've got an awful lot of very hardworking people who are not very well paid for what they do. There's a sort of daily attendance allowance, you know, giving of their time to serve the legislative process, which I think improves its process much more than if they were all democratically elected and had all the validity and rights of a member of Parliament.
Since you brought the subject up of compensation, one of our most recent questions, and I should have announced it earlier, is anybody does have questions, please put it in the Q&A, and we have 3 questions which I will be working my way through. The most recently is Angela Jackson asked, is there a case now for House of Lords member expense allowances to be means tested?
Yes, you could make that case. They've recently introduced or reintroduced a right for members of the House of Lords to claim for the cost of overnight accommodation. So typically there was quite a scandal about 10, 12 years ago of members of Parliament and members of the House of Lords fiddling their expenses or claiming too much on their expenses, and claiming for houses that they weren't occupying, for example. And so they very much simplified the process. This was long before I joined. And so now all that a member of the House of Lords is compensated for is your travel to London, if you have to travel to London to attend, and you get a daily stipend of, I think, approximately £320 a day for attending. And that is not means tested. Everybody gets the same. But of course, those who do not live near London, and particularly those that live a long way away, have to incur the cost of accommodation, etc., when they're there. And they've just this past couple of weeks introduced an overnight accommodation allowance. I think it was announced at £120 per night, which won't get you very comfortable accommodation in London, and is noticeably about half of what the MPs get for their overnight accommodation. But it does recognise, and the challenge I find with the House of Lords is that it tends to favour people who live in and around London and the southeast of England.
Sure.
And the voices of the regions, I'm from Devon, which is, you know, a good few hours out of London, and you know, the voices of the regions are not so well heard. And I think the Lords really does have a duty to be a voice of the whole country, and not just those who live in and around the southeast of England. That doesn't really answer the question with respect to means testing. I don't think means testing is an appropriate way of remunerating. I think the whole idea is those who are within the House of Lords are there, you know, without fear or favour, and you don't have to necessarily disclose all of your personal wealth and earnings, etc. in order to become a member of the House of Lords.
I suspect also that there is a culture whereby, wealthy members, wealthy peers do not claim expenses, even though they're entitled to do so. I would imagine there's a lot of that.
And your allowances and what you do claim is all available for public consumption. And you certainly see quite a lot of commentary on those that never appear in the House of Lords, for example, those who take their seat but don't attend, and equally those who attend regularly but don't necessarily contribute. So there is quite a lot of sort of commentary and eyeballs on who does what, and so I think most people who attend certainly feel that they are being watched and they should be doing a good job.
I imagine there is a certain amount of what I might refer to as peer pressure in that area.
Indeed.
I'm going to run through some of the questions. Our distinguished former president, Adam Siegler, asked, do they have law lords sitting in the House of Lords, and what is their role?
So the House of Lords used to be the highest court in the land, and certainly when I was a junior barrister in England, you if you were taking an appeal all the way to the top, you would have your final appeal in the House of Lords, and the members of that court were sitting members of the House of Lords. In 2005, I think Tony Blair abolished that, and we created a Supreme Court, which means that no longer do members of the highest court in the land automatically take a seat in the House of Lords. But there are a number of retired judges, retired law lords, recently retired, who sit in the House of Lords, and for the most part, they sit on the crossbenches. So I was privileged enough the other day to welcome Brenda Hale to the crossbenches, and she sat next to me on her first day in the House, and she, as you can imagine, one of the most charming, and she was the president of the Supreme Court when Boris Johnson was told that he was unable to prorogue Parliament in the way that he did, and she famously became quite a high-profile jurist as a result of slapping him on the wrist. But she has recently joined the House of Lords on the crossbenches, and their wisdom is very much heard, listened to, alongside a number of really quite prominent sitting, not necessarily judges, but barristers, etc. David Anderson was my roommate for a number of years in the House of Lords. He's a KC, former investigator of international crime, I think, on behalf of the government for a number of years. But there are many sort of leading lawyers sitting in the House of Lords who have been appointed to that position as life peers.
Some other questions, one from Judge David Cowan. Do the Lords ultimately have any veto power as a legal matter, even if rarely used? Does legislation require approval from the Lords?
Yes, so legislation requires approval from both houses before it can be passed into law. The principles are that since 1911, I think, the Lords cannot stop a money bill. So any piece of legislation that involves the raising of finance for the Treasury cannot be vetoed by the House of Lords. Since then, and since the 1940s, there's been a convention whereby if a piece of legislation is included in a governing party's manifesto, that the House of Lords will not frustrate or veto that piece of legislation. And you know, that I think is called the Salisbury Convention. And that's because certainly from the 1940s onwards, the Conservatives had a major majority within the House of Lords, and it was considered unfair if a Labour government was unable to pass its legislative its legislative programme, just because the Conservatives had a majority in the Lords. But there's also a rule now that while the Lords can veto government business, if that government business is returned to the Lords in a subsequent session, i.e. if Parliament is prorogued and a new session of Parliament is open, if that same legislation returns, I think the Lords has to pass it. So the Lords can only really slow things down. It can't ultimately block a legislative programme.
You mentioned earlier, you know, about the regional associations that hereditary peers have. Your family's very long, you know, connection with Devon, for example. And to the extent that your local representatives, your representatives in many ways of many of the major families as large landowners. But you also have to consider yourselves as representatives of other interests. I mean, for example, do peers hold constituency meetings or the equivalent of what MPs do when they held surgery, what they call surgeries for their constituents, where people can come to them with questions or concerns or problems, and they'll try to help them? Is there any sort of tradition of that sort of nature in the upper house?
Not really, and I have to tread a little carefully here. When I first was considering applying for the vacancy on the crossbenches, I spoke to a number of people and pointed out, you know, I think as part of my preparation for my elevator pitch, that I was hoping to join the Lords and be a representative of the interests of Devon. And some wise person said, no, hang on, you cannot represent the interests of Devon. That's what the MPs do. They represent the interests of their constituents. A hereditary peer really cannot do that because you're stepping on their toes. So I came up with a rather archaic view of I'm going to champion the interests of the county. And that has a slightly more feudal and militaristic sort of approach. But it also means that you know, I can fight for the interests of Devon without fear or favour. I don't obviously have a political leaning. I'm not Conservative, not Labour, not Lib Dem. But I'm also someone who owns and operates a small business or small, medium-sized business in Devon. You know, I'm a lawyer active in Devon, and I have a family business that you know has been here for a while and would like to be here for a while longer. And you look at a different timeline. And interestingly, very few hereditary peers happen to be Earl, Duke, Marquis, Viscount of the county or town in which they live. Sure. And this is because from the time of Henry VIII onwards, pretty much, well, prior to the Tudors, you would create someone Earl of Devon. My ancestors were created Earl of Devon because they were the power base within the county, and you wanted to bestow upon them a certain recognition of primacy, so that they would bring to your court as the king their power and influence within the region, because you didn't have a tight central control of government. But from the Tudor period onwards, early modern England through to modern England, you would never appoint someone who was the most powerful person in Devon as Earl of Devon, because that would create a rival power base to you. So it's only really the old titles, the Northumberlands, the Devons, etc., who really still occupy the places in which they are the hereditary peer. More recently, people just get nice titles of places they like to go on holiday for the most part. And so it's a nice tradition to play with, and I enjoy speaking on behalf of the county when I'm in the Lords. And I have taken it upon myself to get more involved in Devon than I otherwise would have. I sit on the place board of Exeter City Council. I work closely with Devon County Council and really try to discover. I've taken a seat on the Devon Housing Commission, which is recently formed, to try and understand what the housing needs of the county are, for example. And in that way, when I speak in the House of Lords, I hope to do so with a better informed interest than if I, you know, took no interest in the county.
And a question from Angela Jackson, and we're moving. We've got another 15 minutes left, and I think we should at least mention the dreaded subject of reform. Angela says, is there a case for the House of Lords to be elected afresh at every election, according to the proportions of overall voting. So the upper house has proportional representations, perhaps subject to a quota of crossbenchers. What are your views on reform, Charlie? I believe we were talking earlier, this is something that people have attempted for well over a century and haven't had much success apart from Mr. Blair.
Yeah, it's certainly that is an approach that has been considered. The challenge with giving the House of Lords a democratic legitimacy is you then create a probably unresolvable tension between the House of Lords and the House of Commons. As I mentioned earlier, I think for the most part, most members of the House of Lords feel they don't really deserve to be there and work their socks off to try and justify their existence. If every member of the House of Lords had a democratic legitimacy equal to the House of Commons, where would the power base sit? Because currently it's very clear, even though the House of Lords is the senior house, the House of Commons is where the business comes from. That's where the country is governed from. That's where the vast majority of ministers are drawn from within the cabinet. Interestingly, we currently have the foreign minister sitting in the House of Lords in the form of David Cameron, but that is very unusual to have a senior minister of state sitting in the House of Lords. So it works rather well, the imperfect mess that we currently have, because of this somewhat illegitimate nature of the House of Lords and its membership. If members of the Lords had an equal democratic mandate to the Commons, you would lose that balance, and it would become quite challenging to know which the primary house was.
And you mentioned Lord Cameron. I'm not sure if I'm 100% right on this, but I believe the last Foreign Secretary in the upper house was Peter Carrington, who, in my view, acted in the most honorable fashion after the Falklands War, when he felt that he, as Foreign Secretary, should have, foreseen the invasion. And in one of the very last examples of cabinet responsibility, or that he resigned as the Foreign Secretary as a result of that failure, which is not in any way down to him personally, but taking responsibility for his department. And probably the last occasion where something like that, a resignation on a point of honor, has happened. And I feel it's something that perhaps embodies the upper house more than the lower house.
Yeah, that's probably true. And interestingly, his son, Rupert Carrington, joined the House of Lords as a hereditary crossbench peer shortly after I did. So we've shared a room for a number of years, and he's a rather wonderful gentleman. Not quite as esteemed as his father, but he's played a quite an important role, because he inherited. There is a hereditary role of not the Earl Marshal, but I think there's a similar role whereby he had to dress up somewhat as a character out of Alice in Wonderland during the coronation, and appeared right next to King Charles in the moment of his coronation. And this is a hereditary role that passes through a number of different families, and it happens to be his turn. So he spends a lot of time wearing rather tight breeches.
There's a lot of dressing up on those sort of occasions. One wonders where all of those magnificent uniforms are kept in the intervening years. But
my coronation robes are still in the cupboard, unfortunately, Zan. I didn't get a chance to unleash them.
Yeah. Any chance of changing rules of succession to allow women to become life peers or hereditaries?
Hereditary peers. So I am championing the Daughters' Rights campaign, and it's a program that I've taken quite a lot of effort to. There is there's a private members bill currently in the Commons, championed by Harriet Baldwin, who is a Cabinet Office minister, to open succession to hereditary peers to eldest children, irrespective of their gender. I am the youngest of 4 children. My father was the youngest of 4 children. My grandfather was the only son amongst 8 or 7 children. So we are the poster child for the iniquities of male primogeniture. I think it's ridiculous in this day and age that titles should pass to heirs dependent upon what's between their legs rather than what's between their ears.
And this is only the rule in England. In Scotland, for example, I believe, females can succeed under Scottish law.
And it's not always been the rule in England. We inherited the earldom of Devon, as I mentioned earlier, in the 1320s on the death of the great Isabella de Fortibus, Countess of Devon and Queen of the Isle of Wight, who outlived her husband, her brother, and all her male heirs. Therefore the title was, she was the wealthiest woman in England, builder of the famous Countess Weir, but on her deathbed the title passed from her to her cousin, who was Henry Courtenay, and that is from whence I am descended. So female inheritance is even in my own title is entirely possible.
Please do tell us the story of the Weir very quickly.
So in 1280, Isabella de Fortibus built a weir over the River Exe, just below Exeter. This the purpose of the weir ostensibly was to divert water to power the great watermill of the Countess Isabella, but it also had the added benefit of ensuring that no shipping could get to Exeter, and it all had to stop in the port town of Topsham, which happened to belong to Countess Isabella. It's no accident that we're still fighting over rights to control of the River Exe today. And I'm having an interesting ding-dong with Exeter City Council over the harbour revision order for the River Exe management. So over 800 years, these same issues seem to repeat themselves.
I want to just let everybody know that among your materials is a wonderful Wikipedia article on the reforms or attempts to reform the House of Lords, which shows what an incredibly complex subject it is, all the various different proposals that have been forward. The one I liked particularly was allotment. Allotment involved the drawing of lots, in other words, completely random selection of peers, which apparently was done in ancient Greece, so a lot of classicists liked it. But, I think we're left, are we not, Charlie, at the end of the day, with the feeling that, this is organically what has developed over many centuries. It kind of works. It's kind of hard to defend from a point of principle, but from a point of view of being a viable and reasonably efficient and authoritative body that does not in any way challenge or diminish the House of Lords, it works pretty well. Would you agree?
Yeah, it does work. It does work pretty well. It's possibly the same as the entire British Constitution, in that you would never design it this way. But as we saw last, a couple of years ago, when we had this, terrible sequence of Boris Johnson being Prime Minister and sort of losing the trust of his parliamentary party, swiftly followed by Liz Truss, who I think was Prime Minister for only 42 or 49 days, and then quickly Rishi Sunak, who everybody thought should have been Prime Minister anyway. The way that the British Constitution works, it just works. And in America, obviously, you can't get rid of a sitting president nearly as easily, even though I'm sure people would like to on occasion. But in the UK, it works. And yes, it all seemed terribly complicated, and no one had a rule book for how you deal with this. But we got through it, and it's organic and it's alive. And then to the point of hereditary peers, and we you talk about the allotment process. Some of the crossbench hereditaries who have followed me, Daniel Ravensdale is he's a young nuclear engineer from the Midlands, and then the chap that followed him is a sort of middle-aged secondary school teacher from the East End of London. And then we have a guy who runs, a series of veterinary practices, who joined after him. And so, interestingly, the hereditary peers these days, fewer few of us are like me, which is probably your classic hereditary peer living in a castle and occupying an ancient earldom. A lot more of them are these kind of, relatively normal people who just happen to have a peculiar characteristic, which is they've inherited a hereditary title.
I don't know if I ever told you this, but there is a very eminent dukedom that is currently held by the manager of a fast food restaurant in Laguna Beach.
Right. Well, I'll look forward to supporting his application.
We've only got a few minutes left. I'd like to turn to your other activities that I think are interesting. You're a member of the British American Parliamentary Group. Can you tell us a little bit about that?
Yeah, so the British American Parliamentary Group was really formed with a view to sort of improving relations between the legislatures in the UK and the US. We predominantly, obviously, involve ourselves with members of the United States Senate and House of Representatives. And we have exchange programs and send members of the UK Parliament across to Washington, and members of the legislature in Washington come and visit us in the UK. But we also have relations with individual state legislative bodies. And I know a group went over to Sacramento a couple of years ago to look at how California in particular was legislating for things such as autonomous vehicles, online safety, and areas in which, and environmental law as well, areas in which I think California in particular and the UK are quite ad idem. And so it's a really nice way to get to know legislators in the US and to exchange some ideas and hopefully sort of increase the special relationship, tighten the bonds.
A few more questions just to wrap it up. Jonathan Sue said, my understanding is that peers exceed the physical capacity of the chamber. Is the overcapacity an issue?
No, we rarely all attend. In fact, we never all attend. And there are lots of seats on the steps of the throne and elsewhere that you can cram in if you need to. But it's, typically we are full on a weekday. Certainly Tuesdays, Wednesdays, Thursdays. It can be hard to get a seat at the exciting times. The crossbenches often are fuller than everywhere else, interestingly. I think that's just because we don't have enough seats.
Right. Charlie, I think it's been a fascinating conversation. We're very grateful to you for sparing the time. I know it's well past your bedtime. And are you in Devon at the moment?
I'm in Devon at the moment, yes. Yeah.
And no, actually, it's probably coming up to closing time, so we mustn't keep you any longer. But thank you very much indeed. It's been a fascinating discussion. I've learned a tremendous amount, and we're all extremely grateful to you for participating in this, and we hope to see you in person next time you're over in California.
Well, it's a pleasure, and I was once a member of the Beverly Hills Bar Association many years ago, so it's a pleasure to re-engage with the association, and I hope to visit at some point.
Perfect. Thank you very much indeed.
Thanks. Bye.
Bye, everybody. Thank you.